Hey everyone, I'm David Finz, and on this episode of the Cyber Insurance Imperative, we're going to issue a challenge to the underwriters to provide a solution for a particularly vexing type of claim. I'm talking about claims arising from the mishandling of biometric information. At least in the United States, these claims are largely governed by state laws, the most infamous of which is the Illinois Biometric Information Privacy Act, a statute which has been interpreted by the courts to impose draconian penalties on defendants. The problem is that insureds and their brokers are having an increasingly difficult time finding a home for these matters in the face of mounting losses. Now, many of these cases are brought by employees, since companies have taken to using fingerprints or retinal scans as a form of identification or timekeeping. In one such case, a plaintiff brought a proposed class action against his employer, alleging that the company collected fingerprints without his consent and without disclosing how long it would retain such records. The company reported the claim to its Employment Practices Liability Insurance carrier, who is now challenging coverage for the matter in court. It's not clear from reports in the legal press whether the company also carried cyber insurance, but the EPL carrier filed what is known as a declaratory judgment action, seeking a determination by the court that the timekeeping practices of the company did not constitute an employment practices wrongful act as defined by the policy. And there seems to be some contradictory language in the policy. On the one hand, there is an exclusion for claims that are in any way related to biometric privacy. On the other, the definition of wrongful act includes a breach of implied contract or policy statement, including an employment-related invasion of privacy. And that's why the parties are in court. See, these so-called DJ actions are especially popular with insurance carriers in Illinois, since the law seems to suggest that a judgment from the court is a prerequisite to a denial of coverage in some circumstances. Regardless of the outcome here, these claims are going to continue to dog businesses for the foreseeable future. And it's convenient for insurers to exclude them under both their cyber and EPL policies, but that leaves the insured without an effective risk transfer solution. I can understand underwriters not wanting to cover fines and penalties that are punitive in nature, but at the very least, they should be willing to cover the defense of such matters, which would also have the effect of opening the door to a contribution to settlements to save on the cost of defense, provided that there is no admission of wrongdoing on the part of the insured. Not incidentally, this approach would also put the underwriters in a position to incentivize best practices on the part of their insureds. They could ask the insured about their data collection policies and how these policies are enforced. Folks, biometric data isn't going away anytime soon, and without a way to safeguard businesses against the expense of lawsuits such as these, we're going to end up stifling innovation and leave American businesses at a competitive disadvantage. Ask yourself whether businesses in China are worried about getting sued by their employees for scanning their fingerprints. Here at Alliant, we care about these issues because our goal is to help you discover the more rewarding way to manage risk. So DM me on LinkedIn or email me at david.finz@alliant.com, and I'll be happy to review your existing cyber and EPL coverages and offer my recommendations on how to make the most of these important policies. Thanks for watching.